The letter arrived on a Tuesday. No warning, no phone call, just a white envelope with a bank logo in the top left corner and 3 sentences that changed everything. Marcus Hale had $50,000 in that account. Money he had saved over 11 years working double shifts at a logistics company in Columbus, Ohio. Money that was supposed to be a down payment on a small commercial property, a dream he had been building quietly, carefully, the way working people build things. Slowly, painfully, without shortcuts. The letter said the account had been closed, effective immediately, due to suspicious activity inconsistent with account terms. He read it 4 times, standing in his kitchen. There was no phone number to call, no case number, no explanation of what the suspicious activity was. Just a sentence at the bottom that said his funds would be held pending review, and that he could expect further communication within 30 to 90 business days. 30 to 90 business days. Marcus called the bank that same morning. He was transferred 3 times, placed on hold for 40 minutes, and then connected to someone who read from a script and told him she couldn't discuss the details of an ongoing compliance review. He asked when the review had started. She couldn't say. He asked what triggered it. She couldn't say. He asked if he could access any portion of his funds for living expenses. She said no. He hung up and sat in silence for a long time. This was March 2019. Marcus was 44 years old. He had no other savings account. The $50,000 represented almost everything he had. What happened next took 2.5 years. And it started with a receipt he almost threw away. To understand how Marcus got here, you have to go back to 2017. He had started making larger deposits that year, not because anything illegal was happening, but because he had taken on a second job doing weekend deliveries for a small freight company called Archer Transport. Cash, payments, weekly. He'd deposit them every Monday morning, usually in amounts between $800 and $2,200. He did this 61 times over the course of 18 months, to the bank's automated fraud detection system. This pattern looked like something it was programmed to flag. Regular cash deposits under $10,000, the federal threshold that triggers mandatory reporting, arriving at consistent intervals from a customer who had previously only direct deposited a single paycheck twice a month. It looked, to an algorithm, like structuring, a federal offense where someone deliberately keeps deposits below reporting thresholds to avoid detection. Except Marcus wasn't structuring anything. He was just depositing his paychecks. The problem was he couldn't prove it. Not easily. Archer Transport had gone out of business in late 2018. The owner, a man named Dale Richter, had moved to Arizona. The company had no website, no active phone number. And Marcus, who had trusted the informal nature of the arrangement, had kept most of his pay stubs in a cardboard box in his garage. A box that had been partially destroyed when a pipe burst that winter. The bank never investigated any of this. They simply closed the account and froze the funds. Marcus hired an attorney named Patricia Owens in April 2019. She filed a formal dispute letter immediately, demanding the bank provide a detailed explanation of the compliance decision and documentation of the specific transactions flagged. The bank's legal team responded 6 weeks later with a 4-page letter that said, essentially, nothing. Legal language, regulatory citations. The phrase, "within our rights," under applicable banking law, appeared twice. Patricia filed a complaint with the Consumer Financial Protection Bureau. The CFPB opened an inquiry. The bank responded to the inquiry. The CFPB closed the inquiry with a determination that the bank had followed proper procedure. Marcus had now spent $4,200 in legal fees. He still had no money. What changed everything was something so small it barely registered at the time. In September 2019, Marcus was going through the damaged box from his garage. He had done this before, sorted through it, found nothing useful, put it back. But this time, wedged underneath a water-damaged insurance document, he found a single receipt. A carbon copy, the old kind, printed on thin, thermal paper. It was from a gas station in Whitehall, Ohio, dated the 14th of June, 2017. And clipped to the back of it by a rusted paper clip was a handwritten payment record on Archer Transport letterhead, signed by Dale Richter, listing Marcus Hale's name, the date, and a payment of $940 for services rendered. It was one receipt, one payment record, out of 61, but it was enough. Patricia located Dale Richter through an Arizona business registry. He had started a new freight brokerage there. She contacted him. He remembered Marcus. He had records, digital records, backed up to a cloud account. He had forgotten, he still had access to, showing 61 individual payments to Marcus Hale between April 2017 and September 2018. Total amount, $94,300. They had the documentation. In November 2019, Patricia filed a civil lawsuit against the bank in federal district court. The claim was wrongful account closure, violation of the Electronic Fund Transfer Act, and damages resulting from prolonged withholding of funds. They asked for the $50,000 plus interest, legal fees, and $180,000 in compensatory damages for financial hardship. The bank's attorneys filed to dismiss. The judge denied the motion. Discovery began in early 2020, and this is where things got uncomfortable, not for Marcus but for the bank. During the discovery process, Patricia's team requested internal communications related to Marcus's account. What they found was a chain of emails between two compliance officers dated February 2019, 1 month before the account was closed. In one email, a compliance officer wrote that the system had flagged the account, but that, quote, manual review shows pattern consistent with secondary employment. In other words, someone at the bank had looked at Marcus's account, seen that it was likely a legitimate second income, and noted it. Then, a second email, 3 days later, from a senior compliance manager. Proceed with closure. We're over capacity for manual reviews this quarter. They had known, or at least they had had reason to believe, and they had closed the account anyway. Patricia brought this evidence to mediation in August 2020. The bank's legal team, who had spent 18 months arguing this, was a routine compliance decision made in good faith. Now sat across a table with an email that said otherwise. The mediation lasted 1 day. The settlement agreement was finalized on the 3rd of September, 2020. The terms were sealed, meaning the exact figures were never made public, but Marcus's attorney was permitted to confirm, on record, that her client received his $50,000 in full, plus interest, plus all legal fees, plus additional compensation. She described the outcome as complete. Marcus did not give interviews. He didn't post about it online. He signed whatever he was asked to sign and went home. He bought the commercial property in February 2021. A small building on the east side of Columbus, 2 rental units on the ground floor, a storage space in the back. He paid in full, cash, wired from his account. There is a detail that stays with you when you know this story, that carbon copy receipt from the Whitehall gas station. The one that started everything. Marcus had almost thrown it away. The night he found it, he was tired. The box was mostly garbage. He had set the receipt aside without really looking at it and was about to toss it when something made him flip it over. A reflex, a habit, the kind of thing you can't explain. One piece of paper, saved with a rusted paperclip, under a water-damaged insurance document, in a flooded garage. That is what $50,000 looked like. That is what 2.5 years of someone's life looked like. Not in a courtroom, not in headlines. Just a receipt he almost threw away on a Tuesday night in September. There are millions of accounts closed every year in the United States for compliance reasons. Most people never challenge it. They don't know they can. They don't have the documentation. They don't have the lawyer. They don't find the receipt. Marcus Hale did. And a bank that moved too fast, cut too many corners, and sent one too many internal emails, learned something about what happens when ordinary people stop accepting the answer they're given and start looking a little harder through the box.